Welcome, a warm welcome from Dallas, Texas. My name is Maryam Baig, and I will be your host today and moderate the panel. Thank you for joining us. Before we get started, we'd just like to say that this past week has just been a flood of information, news in part because of Judge Hannon's decision declaring DACA unlawful. We're here in Texas, and it is important for us to remember that that happened because of the officials here in our backyard who represent us, who have decided that targeting immigrant people is a good political decision for them. We need to loudly let them know that their calculus is wrong. Today's panel is for us to discuss what the Biden administration has been up to, so we won't spend a lot of time on that decision. But before I jump in, I want to mention a few things. To our documented friends and family, we are here with you. If you already have DACA, it's important to know that your status is unchanged right now, and you have rights. Be sure to renew your DACA as soon as you can. For anyone applying for the first time without a decision yet, things are frozen. Unfortunately, until something changes, your application cannot be granted. The roller coaster that our documented friends and families have lived through over the past several years is unacceptable. It makes it obvious how important immigration relief for immigrant youth, TPS holders, farm workers, and essential workers is. Congress, not the Biden administration, is in charge of making that happen. And they have the opportunity right now, through the budget reconciliation process, to make that happen. If you haven't called your congressional member about this yet, call them now and demand a pathway to permanent status. This is just the current news. At the same time, we know there is so much in immigration that administration can control. Our purpose today is to talk about what's been going on in the past 6 months and why immigration continues to need your urgent attention. Thank you for being here. We will start with the bans. In January of 2017, the former president signed an executive order, it's called Order 13679, called Protecting the Nation from Foreign Terrorist Entry into the United States, which is intended to screen out radical Islamic terrorists. The executive order included many aspects, but basically banned the entry of foreign nationals for 90 days from 7 majority Muslim countries: Syria, Iran, Sudan, Libya, Somalia, Yemen, and Iran. And they halted the flow of refugees from Syria until further notice. There have been 3 versions of this ban, and they have been blocked, challenged, and upheld at various points. It is my pleasure to introduce you to Bill Holston, the Executive Director of HRI. And Bill, you know all about the bans. So can you tell us what was the facial justification of this? Like, then what was really happening?
Almost every activist I know in the city of Dallas was at DFW airport when this ban got rolled out. It was utter chaos, but it was a beautiful thing to watch our community respond immediately to that, and lots of people that just ordinary citizens went up there and spoke out, as well as many lawyers there representing people. But it was chaos, and of course it was a transparent assault on the rights of our Muslim siblings to simply migrate here or just visit here temporarily to the United States.
So Bill, can you tell us where it stands now?
Well, it's gone. Thankfully, it was a relatively straightforward thing to do away with. It was done by 3 executive orders, and our current administration was able to undo it with a single executive order. So that was changed and happened quickly and decisively.
Bill, just to make things clearer, how did it happen and why?
Well, why is it was a transparent political effort to make political hay at the expense of people simply because of their religion, and so it was an appeal to the basis elements in our country. There was no legitimate reason why we should be banning people because of their religion from entering the United States.
Well, Bill, while I have you here, I was wondering if we could talk about public charge. Friends, public charge is a ground of inadmissibility that could bar an individual's admission to the United States on a visa or application for lawful permanent residence if the government determines the individual is likely to rely on certain public benefits in the future. Now, this was interpreted broadly to reduce the number of people who were eligible for green cards and other visas by redefining what made them dependent on government benefits or likely to be in the future. So, Bill, what was the justification of this? And then what was actually happening?
Well, this rule was based on the immoral idea that there was something wrong that immigrants should with immigrants accessing government benefits, and wrong that people in general should be accessing government benefits, which are things that are available to people because of the situations they find themselves in. And it put the fear into immigrant communities that they would jeopardize their ability to later become a citizen or a permanent resident simply by accessing emergency relief, food relief, rental assistance, or even a public school education. The people were terrified of putting their immigration status at jeopardy.
So, so where is that? Where is public charge now? Where does it stand now?
Well, again, thankfully, the government was able to address that fairly efficiently and easily early in the administration, and set that public charge rule aside. And then contacted all government agencies to let them know about this rule change. And that happened because immigrant communities stood up against this immoral action and spoke out. And so because there was a lot of fear, and it actually did prevent people from accessing benefits that they would ordinarily been entitled to. So we're very thankful that that is gone.
Thank you, Bill. It is indeed on both the Muslim ban and on the public charge. This is indeed good news, and the new administration has indeed moved quickly on these. Friends, we support all of our community organization, our partner organizations for the work they do, and we continue to be dedicated to these. If you have any questions about them, you can drop them in the chat. We have a lot to cover, so we may not get them right away, but we will make sure you have the information. And if you need any information to support this work, it's really it's community advocates and community partners whose dedication made this happen. Speaking of making things happen, one of the terms that comes across the news often, and some of us know about it and some of us know, is the U visa. U visa is a special non-immigrant visa classification. It was specifically created by the US Congress for victims of certain crimes who have suffered mental or physical abuses, and they are helpful to our law enforcement or government officials in the investigation or persecution of criminal activity. The purpose of the U visa is to protect certain victims of crimes, while at the same time ensuring that those perpetrators of certain crimes are brought to justice. Now, unfortunately, during the last administration, there were harder lines that were taken on it. And while people waited for their U visa to come on in, they became vulnerable to detention and deportation. It is my pleasure to introduce to you Zeyla Gonzalez, Director of our Crime Victims Program. Zeyla, we keep hearing that there's a backlog, there are not enough U visas, etc. Could you tell us why is there such a big backlog on U visas?
Thank you, Maryam. So when Congress created the U visa program under the Violence Against Women Act, they said that there was going to be a limit on the number of U visas that could be issued on any given year. And that number was set at 1,000 from the beginning of the program, and that has not changed. And that's what we refer to as the U visa cap.
All right, thank you. Wow. Well, if there is a statutory cap set by Congress, how does the administration have any control over improving the backlog?
So as I said, right now with Congress creating that backlog because of that U visa cap, initially it was not a problem. At the beginning of the program, the U visa program, there was not a lot of people applying for a U visa application. However, throughout the years, that has changed. In part because there has been a lot of community effort to educate people about U visas, educate law enforcement about U visas. And it's a great thing because a lot of people qualify for this and have applied for, have begun to apply for this year after year, which every year there's more applicants. Currently, we stand at about 160,000 applications pending. And so to answer your question about how the Biden administration, no, they cannot change themselves the number, the 10,000 visa cap that we have. Only Congress can change that. But Maryam, one of the things that our administration can do is that they can issue people work authorization, work permits while they are waiting. I talk to clients every single day, and one of the most frustrating things about waiting for a U visa for years and years is that they aren't able to work legally. And so the majority of the clients that I work with are single moms. Women who have left abusive situations and now have children that they have to raise on their own. And as you can imagine, that's a financial strain, especially when you don't have a work permit to obtain legal employment here. And so what the Biden administration thankfully has announced this year is that they are doing things a little bit differently with the goal to have people obtain their work permits a lot sooner. And now this was just announced probably about a month ago now. And so it's still, it's in its early stages. We still have yet to see how quickly that will be processed, but we do have faith that under the new administration, people will at least be able to get their work permit sooner. Right now, people who apply for a U visa as of this year, we anticipate that they will be waiting about 10 years for a final decision. But at least a work permit, will give them some relief.
Zeyla, thank you so much. So just to quickly recap, the cap is at 10,000 right now.
Mm-hmm.
The wait time is predicted at 10 years.
Mm-hmm.
So one of the things that Congress can do is to allow work permits to come in for folks while they wait. So 10 years, how do you support yourself legally while escaping abusive situations? I think there are some things that you said that really jumped out at me, which was education on part of knowing what this is, advocacy, speaking up for U visas, and community programs and community partners who stand up and work for it. Thank you so much, Zeyla. Thank you for telling us. And folks, if you have any questions about U visa, please drop them. HRI's program under the keen leadership of Zeyla Gonzalez is working tirelessly for our U visa clients, and we will continue to do so. Well, you simpler because I'm about to bring up matter of AB or matter of LEA. Gosh, what are all these acronyms? What do they stand for? So let me give you a quick background on it. So every day, thousands of migrants, asylum seekers, and refugees make the incredibly difficult decision to leave their countries in search of safety or better lives. Now, there is a slight difference, and sometimes people ask me, which is, is there a difference between a refugee or an asylee? And so let me just say this: if they apply for protection from abroad and are granted protection, they're considered refugees. If they apply for protection from within the destination country and are granted protection, they're considered asylees. Now, an asylum seeker is also someone who's seeking international protection from dangers in his or her home country. However, asylum seekers must apply for protection in the destination, which means they must arrive at or cross a border in order to apply for that protection. It is everyone's legal right to seek asylum. Please, let's be clear on that. And as a signatory to the 1967 United Nations Protocol and through U.S. immigration law, the United States has a legal obligation to provide protection to those who qualify. It can take years to happen, and it is complicated, sometimes costly, and very convoluted. Throw in something like AB. Now, these are policies that limited asylum eligibility for domestic violence survivors and others. And there were two decisions that were issued by former Attorney Generals in the previous admin. It is my great pleasure to introduce to you Ms. Emily Heger, who is our AT&T Aiken Gump Strauss Hort and Feld LLP Equal Justice Works Fellow. Emily, thank you for being here. And I have saved all the complicated stuff for you to explain. It drives me insane when I read about AB or a matter of LEA. So tell us what happened under the former president's administration to this category of asylum.
Thank you, Maryam. I think first it's important to note that when you're applying for asylum, you have to prove that you have a qualifying protected ground. And so there are certain categories enumerated in the asylum statute, and one of them is particular social group. So these two cases, matter of AB and matter of LEA, both revolved around particular social groups, right? So in essence, what we saw the former administration attempt to do was narrow this definition of particular social group protected ground to essentially have less and less asylum seekers eligible for relief here. In both of those cases, the former attorneys generals reopened the cases to themselves to issue new and narrowing decisions. In matter of AB, the asylum seeker was fleeing years of horrific domestic violence from which her government was unable and unwilling to protect her. And so when the former attorney general opened that decision, overruled it, denied asylum for her DV-based claim, it in effect shut the door on domestic violence, all of future domestic violence asylum claims. And similarly, in matter of LEA, that was a case where the asylum seeker was fleeing gang-based targeted violence because of his connection to his nuclear family. And the former attorney general reopened that case and decided that, made a decision that family-based particular social groups were no longer likely viable. I know. And what we know is so many people that are fleeing gang violence are targeted because of their nuclear families, right? And so that decision too just essentially walled off access to asylum relief for so many people that needed it.
Gosh, Emily, so already a complicated system of applications and complicated laws surrounding it, often to folks whose first language might not even be the language of their destination country. And then you throw in this, basically using two cases to narrow the parameters on whom the United States could allow entry and protection. Oh, dear
Exactly.
God. What have the advocates been pushing for these protections? What have we heard from our advocates?
So in short, what we were arguing for the last 4 years is that both matter of AB and matter of LEA were a breach of years of established case law, right? So both of these cases, we argue, went in a new and a different direction that was incorrect. So the effect of what we saw coming out of these two cases, and there were many effects, but one major one was that it caused just utter confusion in the immigration courts. As you said, this is quite complicated, right? So that after these cases, we were seeing immigration judges just not being able to confidently interpret asylum statutes or asylum case law because these new decisions went in entirely new directions. Another effect, though, out of these two cases was that we saw, unfortunately, kind of a chilling effect among the legal services community because these decisions were considered to, in effect, make domestic violence or gang claims non-viable, impossible to win. We saw so many, both nonprofits and private immigration attorneys, turning away domestic violence or gang violence asylum clients because these cases were now considered impossible. So to me, and I know to us at HRI, that was one of the worst effects of these two cases.
I hear you. And the one of HRI's program is our annual storytelling project. And one time I ended up working with a child, an underage client of ours, who told us his story where he had to flee from a gang while he was 8 years old. And if he didn't run away, the gang basically described how they would mutilate and murder his family. And to find out that we're closing our doors on sometimes children is just heartbreaking. So just to reiterate, what does the rescission mean from a practical standpoint? What does it mean from a practical standpoint for people?
Yeah, it means that domestic violence and gang-based violence claims are once again have a fighting chance to win asylum. I'll say that these are by no means easy cases. I want to be clear about that, but they're no longer considered impossible. So courts are supposed to act as if matter of AB and matter of LEA never happened. So we get to go back to case law as it was before these two horrific cases went into effect. So we still have to build strong asylum cases. We still have to prove each and every element of asylum law, and that's a very heavy burden, but it's possible. And so I hope this also means that for folks who are fleeing domestic violence and gang violence persecution, that they'll once again also have access to an increased legal services community, because we're all understanding that these cases are winnable and we're willing to take up that fight once again.
There has to be something to be said about difficult times. I'm an immigrant myself, and I was always like, the system is so complicated. But now the difficulties just shot through the roof, and we're just happy to have the difficult system back and not the crazy system. Oh, gosh, I'm about to talk about one of my favorite subjects, which is ICE. And I was going to make a joke about it, but you know what, folks? Maybe I can make a joke about ICE some other day, because it is one of the most serious issues that comes out in immigration in America today. So ICE was created in 2003 through a merger of investigative and interior enforcement elements of the former U.S. Customs Service and Immigration Naturalization Service. ICE has now more than 2,000 law enforcement and support personnel in more than 400 offices across the United States and around the world. I totally looked this up from the ICE website, so I get it exactly right. So to bring into this discussion, I want to introduce you to one of my partners in crime, feeling all the feelings about this, Cohn, who is our Director of Community Education and Advocacy. Callie, let's start by letting our community know, how does ICE make decisions about who they target for removal?
Yeah, well, so as Maryam explained, ICE is part of our executive branch. And so that means that the person who's in charge of the executive branch, so our president, really sets the tone about how ICE does its work. And so as Maryam explained, ICE's main job is to enforce our immigration laws here in the interior of our country. And part of that job is identifying people that they would like to put into the deportation process, so people that they're going to kick out of the country. So one of the assumptions historically that was built into the way that ICE did its work is the idea that the idea that we do have limited resources. And so ICE would never, even if it wanted to, and certainly under the Trump administration, it did, be able to find every undocumented person in the country. And so historically, what's happened, particularly over the last decade, is that ICE has done what they're calling prioritize certain categories of people for deportation.
Okay. So since it's an executive branch and it is molded by the decisions of our leader in charge, what happened under the former president's administration?
Yeah, so as I mentioned, there has been this attempt to, quote, prioritize people for deportation. What happened under the Trump administration was really that he eliminated most prioritization based on criminal history entirely. So from a practical standpoint, that meant that nearly every undocumented person in the US to ICE became a priority for arrest. And so they started conducting operations in places all over. We saw a lot of interior enforcement. We saw a lot of raids. We also saw specific targeting by ICE in states and localities that had tried to put in place policies to protect people. And that was specifically to retaliate against those states and those localities from doing that. So that's in part what happened. But I think there are two really important things to understand here. So the first thing is that because of the ways that systemic racism, the criminal justice system, and the immigration system all intersect, when the government says, I'm going to prioritize people because of criminal history, the practical effect of that is that it prioritizes the deportation of Black people. And so there's a lot of conversation about prioritization, and I'll talk about that a little bit more in a minute. But I think it's really important to understand what happens in practice, which is really the targeting of Black people in the United States. The second thing that's important to understand is that just because the Obama administration said that it wanted to prioritize people with criminal histories, that didn't mean that everyone else was safe. If you look at the data back in 2015, for example, 40% of the people in ICE detention didn't have any criminal conviction. That's a lot of people. Now that flipped under the Trump administration. We saw more people. By the same time of year 2019, 65% of people in ICE detention did not have a criminal conviction. But across the two administrations, we were seeing people with no criminal history swept into our deportation machine.
Dear God, Callie. I will take a moment to recognize how ashamed we feel and how systemic racism is prevalent in every section of our society. It is especially connected to immigration. But maybe we can have a little bit of hope. So what does the new policy change mean for ICE?
Yeah, so there was a lot of news when the Biden administration took over. One of the things that he had promised was this 100-day, he was calling it a 100-day moratorium, so a 100-day stop on deportations. Of course, we're past the 100 days, we're 6 months in now, and so that's no longer in place. But part of what the administration did is that he put in place new enforcement priorities, and those affect who's supposed to be stopped by ICE, who's supposed to be questioned by ICE, who's supposed to be arrested by ICE, and also whether the government is ultimately going to prosecute those people and try to convict them of deportation. And I'm using convict loosely because it's a civil proceeding. It's not a criminal proceeding. So the policies that are currently in place under that new policy prioritize people who the government considers national security threats, anyone who is trying to enter our border after November 1st of last year without a way in, and then finally people who have been convicted of aggravated felonies or crimes involving gaming activity. And the government has said, we think these people are public safety threats. The reality of what we're seeing right now is we're seeing detention numbers rise, and the model, this enforcement priorities model, continues to import the racism and biases inherent in our criminal justice system that we've talked about already. And so I want to share that advocates are really asking for a different kind of model, and that instead of a enforcement priority model is a protection first model. The idea being that we should affirmatively be protecting undocumented people from deportation when, for example, it's in the interest of justice, when their deportation would separate families, which is happening a lot. We talk about family separation, but we hardly ever talk about it in the context of ICE, and that's happening so much, or when there are humanitarian issues involved. So I think all of this can feel a little bit hopeless, but the real takeaway here is that this is another reason why we need a pathway to citizenship, why we need the relief that Maryam talked about at the very beginning of this, and why we need comprehensive immigration reform. So we'll put up the link again, but We Are Home is the big coalition working on this, and I would really encourage everybody to follow them and follow their action alerts to be able to help move the needle on this.
Oof, Callie, thank you. Folks, in a quick jiffy, if you want to look some of this up, you can look up the hashtag We Are Home or the hashtag Welcome with Dignity. Dignity is a top priority. These are human beings we're talking about. And thank you, Callie. Zeyla mentioned at the top of the panel, education. Emily talked about advocacy. Callie's talking about how we must stay dedicated and not lose sight. Folks, like Bill said, we have to keep paying attention. And Callie, you just mentioned family separation, and I just can't help myself. So you guys, you know about family separation, under the Trump administration. It was presented to the public as a zero tolerance approach intended to deter illegal immigration and to encourage tougher legislation. It was officially adopted across the entire U.S.-Mexico border from April 2018 to June 2018. Correct me if I'm wrong, folks. Under the policy, federal authorities separated children and infants from parents and guardians with whom they had entered the United States. The adults were prosecuted and held in federal jails or deported, and the children were placed under the supervision of the U.S. Department of Health and Human Services. A 2021 review done by the Biden administration found out that more than 1,400 parents were ultimately deported without their children. And in January of 2020, SPLC reported that the official government number, this is the official government number, the number with nonprofit orgs is higher. The number of children separated from their parents or guardians under the policy was 4,368. This number is higher, folks. When I get upset about things like this, there's one person I can turn to and ask to be upset with me and talk about it. And Bill Holston, I hope you're ready. I hope you're ready to rant about this with me. I'm counting on you. So tell me, Bill, we all know about family separation, but we don't necessarily understand the mechanics of how the government pulled it off. How did it work?
Thanks, Maryam. It's always been, or for many years, it's been a criminal offense to cross the border without legal authority. And so what the previous administration did was use that as a tool to inflict cruelty on migrants. And they did that by what they called a zero tolerance policy, which was charging every single person, including entire families, to cross the border without legal authority, even those that were legally seeking to cross to claim asylum, with a criminal offense. And they were prosecuted and brought in mass before federal judges to be charged with the crime. And that resulted in the fact that you can't take your child with you to jail. And so they took these children away from their parents and, sometimes even nursing mothers. And that's how they pulled that off.
Well, okay. But there's, some good news on the horizon, and which is why we're conducting this panel to see what this past 6 months have done in a lot of these completely cruel policies. Biden admin has rescinded the zero tolerance policy. Does that mean family separation is over?
No, it doesn't. Kelly alluded to this in her excellent answer, but one of the things that's happening is because of other policies. We'll talk about Title 42, which we'll talk about in a bit. Because you're turning away certain people at the border, they're put in this impossible situation of making the decision of whether or not they remain in very dangerous conditions across the border with their child, or do they send their child across the border alone? And many people are making that excruciating decision to send their child alone into the United States because that will at least keep their child safe. And these criminal laws, of course, still remain in the books. And so that's another reason for legislative changes. It shouldn't be a criminal offense to simply cross the border.
Thanks, Bill. Friends, we're talking straight up legal stuff. This is our work. This is what we do day in, day out. We're not even talking about the social, psychological, financial, especially psychological effects of family separation that this policy has unleashed upon just families who have children, tiny children. And Bill, I was going to say, don't even bring up Title 42. Maybe we should wait on it. I'll pick something easier, but there's nothing easier. Nothing is easier because, folks, I'm going to talk about MPP now. MPP, the Migrant Protection Protocols, MPP, are a U.S. government action where certain foreign individuals entering or seeking admission to the U.S. from Mexico illegally or without proper documentation may be returned to Mexico and wait outside the U.S. for the duration of their immigration proceedings, where Mexico will provide them with all appropriate humanitarian protections for the duration of their stay. Sounds like an idea, but hey, Emily,
hello again.
I'm not going to repeat your long title, but Emily is our Legal Works fellow. Thank you, Aiken and Gump, plus AT&T for letting us have her. Why, Emily? Why is waiting for your asylum case outside of the country so dangerous?
Yeah, well, for starters, I'll clarify just one point because, as you said, it is so complicated. But MPP was a policy put in place for anyone that arrived at the U.S.-Mexico border. So they're not necessarily all from Mexico. Now, they came to the U.S. border by way of Mexico, but they're oftentimes not Mexican nationals. And so when they're returned to Mexico, while they wait for their U.S. immigration proceedings to take place, what we saw in effect were tens of thousands of asylum seekers forced to live in these squalid tent-made camps. These were people that were arrived at our border and, as you said earlier, were lawfully asking for asylum, asking for humanitarian protections, and were turned away. And so, they weren't planning on being turned away. They oftentimes were not prepared for the resources necessary to live on their own in these Mexican border communities. And so they were reliant on the generosity of nonprofits for things like toiletries, food, tents, blankets. I mean, they were at such risk. And so naturally, as you can imagine, when the entire world was struck by the COVID-19 pandemic, it was impossible to exercise any form of social distancing or other public health measures. So coronavirus, that disease ran rampant through these refugee asylum seeking communities that we as Americans, our US government made possible or made just required. But even before the pandemic, these asylum seekers forced to remain in these tent communities in Mexico under MPP were in extreme danger to be targeted by the cartel. what we saw was that because these asylum seekers were seeking asylum in the United States, the cartel assumed that they therefore had connections in the United States and then therefore had connections to financial resources in the United States. So many asylum seekers under MPP were being kidnapped and held for ransom, or their children were being kidnapped and held for ransom, to upwards of $20,000 required to pay just to be released from the cartel. So many of the MPP folks that we worked with were subjected to these kidnappings, to horrific sexual assaults, physical attacks. To be honest, the experiences that they either endured or witnessed, they're too horrific to even talk about here. But yes, it was very dangerous.
Emily, thank you. Emily's work, our mission serves immigrants and refugees who are in North Texas, but thanks to a program that Emily ran, the legal clinic, we were able to provide some support and some work with some MPP cases and people. Friends, we received so many social media requests during this time from people who are completely desperate. Their kids have been kidnapped, their daughters have been sex trafficked, they're missing their dads. Sometimes it's for like $20,000 is a blessing. One time, the amount they said was $18,000 to me is a blessing. I would pay the 18. I will figure something out. But how do I get my children back? There's no guarantee. Now, this is the social and psychological aspects. Emily, what happens to the case? Why is it harmful to the case when these immigrants and refugees are waiting on the border?
Yeah, it's arguably an egregious violation of their due process rights. Right? So when you're forced to remain in Mexico while you have a U.S. immigration case proceeding, they were in effect cut off from any access to meaningful legal aid, legal representation. I just described the chaotic and traumatic conditions within which they were living. So just effectively being able to put together any form of meaningful removal defense was nearly impossible. I'll say that even for the few cases that we were able to contribute to working with, the folks that we were able to work with, it was only because there was a network of nonprofits who refused to give up on these people. And so we're talking literally 4 to 5 organizations collaborating to help one MPP asylum seeker with their I-589, their simple asylum application. And even that, the work product was not sufficient, right? We are communicating exclusively via WhatsApp. We're asking them to give us intimate details of their stories while they're in the midst of this chaotic, overcrowded tent community without any opportunity to speak confidentially, right? There are just so many layers to why it was impossible for them to put together an effective defense to the removal or claim for asylum.
Emily, you just reminded me also how various scams, legal scams during this time where dummy websites were put up offering help with the proceedings. There's no way. A lot of these clients don't have cell phones or internet or Wi-Fi, and they're asking their cousins, friends, colleague in another town to like call us, or and finding these scam websites and finding these scam lawyers so hard. So anytime they make contact with us or anyone, it's such a big risk. So were there any changes made? What's the status?
Yes, thankfully. So as soon as the new administration came, they stopped enrolling. The first step was that they stopped enrolling any new people into the MPP policy, which was great. Shortly after that, they announced a program to allow MPP folks to enter the United States during the duration of their immigration proceedings. They called it phase 1 of this process, and phase 1 was open exclusively, though, to MPP folks that had pending cases before immigration court. So if you had already lost your case in immigration court and you were ordered removed, or if you were appealing your case either to the Board of Immigration Appeals or the circuit courts, you were not eligible under phase 1 to enter the United States. Unfortunately, you still had to remain in Mexico. Recently, they've announced a phase 2 of this program, which is specifically for folks that were issued an in absentia removal order under MPP. And this is great. So an in absentia removal order means that you were ordered removed because you did not show up to your MPP hearing. And because of everything we've already talked about, we know that the people that didn't show up, they didn't show up because they were in the midst of being kidnapped, because they were sick with coronavirus, because it was just otherwise too unsafe or too risky for them to travel back up to the border for these hearings. And so they were ordered removed without ever actually getting to be present in the court and make their defense. And so our new administration has said for those people, you can register with DHS and you can have your cases reopened. During that time, you're allowed to enter the United States, apply for your work authorization, and effectively get to work on your removal defense from within the United States. The last thing, though, that I'll add, just all of that said, is our partners and advocates, organizations that are on the ground in helping MPP people directly, MPP folks directly, have said that they have not seen phase 2 rolled out yet. So we're still waiting on the administration to initiate this phase 2 that we're hopeful for.
Well, certainly some good news. And I know we spoke about it at our recent staff meeting, and we were like, oh my God, there's some hope on the horizon. One of the things that really breaks our heart are the children who are stuck in these MPP camps, often known as UAC, the unaccompanied alien children. So it is a United States government classification for children in immigration custody in the name of a program operated by the Office of Refugee Resettlement, which is a division of the United States Department of Health and Human Services, to house and care for them. But this is when the children arrive unaccompanied. The term designates unaccompanied minors who are aliens, typically those who have been apprehended outside of a legal port of entry or judged inadmissible upon their entry. So what happens with those children? For that, I'd like to introduce you to my good friend, the amazing Carolina Piña, who is the case manager and legal assistant for our children's program. Hey, Carolina.
Hi, ma'am.
Let me start you off by asking you something that was in our past. We used to be a shelter provider, right? What was the shelter like that we visited?
Yeah, so we used to work with the shelter here at Catholic Charities Dallas and Fort Worth. Our shelter was small compared to most, especially the shelters near the border can house like over 100 kids. But the shelter here in DFW housed about 20 beds, give or take. And so our shelter was small. I loved the staff that worked at Catholic Charities Dallas. During the school year, the kids are able to attend school, just regular classes. And then during the summer, they still upkeep with activities for the kids for the summer, just to make sure that they're staying active and they don't feel alone at this shelter.
Well, shelters the same conditions?
Yeah, so not every shelter is going to be the same. It depends on how many kids can stay there. It depends on the amount of staff, especially if they're short staff. It can, make a mess of things. And then these facilities are contracted by different contractors. And so, for example, Catholic Charities was our contract. And then some of these facilities are contracted by private prisons. And then those eventually turn into kids detention centers. And so nobody needs to be, prison companies should not be engaging with children, especially in any capacities, much less detention centers.
Oh gosh. So you're putting unaccompanied minors who have been sometimes separated from their families or have arrived at a port of entry without a legal guardian or parent with them. So how do emergency intake sites, like the site that was at the Dallas Convention Center, how are they different from what we're talking about?
Yeah, so regular shelters already have so much to maintain, make sure the kids are safe, make sure they're being protected. And emergency sites are just a bad idea. I mean, if regular shelters already are so strained, putting an emergency site already puts pressure on the kids that are going to be there and on the legal providers that are in that area. So emergency sites are just never a good idea. And I'm sure that you heard that here in Dallas, some of the kids were on buses for hours and hours. And that just goes back to the point of emergency sites are not created for adults, much less children. And that doesn't provide a safe, welcome environment to small little kids who've already been through so much.
Yeah, some of our staff actually volunteered at that shelter. I'm thinking of you, Corey, Ciara. And some of the conditions that they described were heartbreaking. Carolina, not that we need to be reminded, but what are these kids dealing with when they make their journey? And how does the shelter experience layer on that?
Yeah, so these kids are fleeing a bad home country, bad environment at home, and they already have to make the long journey to the U.S. border. They are threatened by cartels. They can be kidnapped by cartels. They have trouble finding where to sleep. There's lack of food and water. And so that journey already puts more on their trauma that they're coming with. And then once they get to the border, the least thing that we could do is, we should just treat them well and make sure that the shelters that they are coming into as a country, we should provide a safe environment until they're released to their sponsor here in the U.S.
Carolina, thank you so much. Thank you so much for the work that you do. You guys, every minute, I think how honored I am to partner with people like you doing this amazing work every day. I just want to quickly, and thank you for sticking with us. I know we're throwing a lot of information at you, but I just want to quickly talk about two more things, guys. I promise, just two more things. I want to talk about asylum cooperative agreements, also known as ACAs, with nations of the Northern Triangle, El Salvador, Guatemala, and Honduras. Now, these agreements limit the ability of certain asylum seekers to access critical protections and claim asylum in the United States. I call on my partner in all things rants and these issues. Bill, I think you already unmuted yourself because you knew I was talking about you. Did we have any of these before the Trump administration?
Well, yes, we had cooperative agreements with Canada, which we called safe third country agreements because Canada is actually a safe third country. So if people go to Canada, they can apply for asylum there. What was different about this is we entered into these agreements with Guatemala and El Salvador, which are they're not safe countries these are countries people are fleeing already. And these are countries that lack the resources to process refugees. And so it was really just designed to it wasn't a serious effort to provide refuge to people. It was an effort to just demolish their ability to seek asylum in those countries.
So basically the practical impact was, let's just narrow the possibilities and demolish any hope in seeking these protections. So what does it mean now that they're not in place?
Well, it's a good thing. It means that we're no longer sending people to Guatemala for their asylum cases to be processed, although we have other problems that we can talk about, including the fact that we continue to collaborate with the militaries of Mexico and other countries to try to restrict the flow of migrants to our border, which after all still is legal for people to come to our border and claim asylum, and they shouldn't be prevented by military from doing that.
Folks, a lot of these things have been in the United States government for ages, for decades. Immigration was never an easy thing, but it has become progressively and more cruelly complicated under the last admin. You know what, Bill? Let's just do it. Let's just talk about Title 42, because why are we not talking about it? Folks, even before the pandemic came along, certain White House advisor to the then U.S. president had floated the idea of using the government's public health authority as a means of achieving the admin's long pursued goal of closing the border to asylum seeker. And then the pandemic happened and Title 42 came. Trump administration pressurized public health authorities to circumvent the U.S. and international law protecting refugees by ordering immigration authorities to summarily expel migrants without providing them the opportunity to seek protection in the U.S. Bill, what was the justification for this? And do experts agree?
Well, the stated justification was as a public health measure, but that was belied by the fact that all public health experts at the Centers for Disease Control said there was no necessity for doing this. It was referred to at the time as a Stephen Miller special, that was using the excuse of protecting public health to deny asylum seekers access to the United States. And it's resulted in, yeah, go ahead, Maryam.
I'm sorry, I know. Bill, were there any particular communities that are being disproportionately impacted by this?
Yeah, as Callie pointed out earlier in talking about detention, the same has been true with Title 42. It's disproportionately impacted communities of color, and particularly Haitian asylum seekers, as called out by our friends at Haitian Bridge Alliance, and Black migrants from African countries like Cameroon and Congo. Because the fact is that, single adults from African countries, it's common for them to travel as single adults. And so the fact that they're turned away at the border means that you have a disproportionate number of Black migrants that are affected by this policy. And it was called out yesterday by public health experts and DC with the Welcome with Dignity campaign, pointing all of that out. And I also mentioned that a number of commentators like Maria Hinojosa with Latina USA and her blog, they're calling there's more and more attention to the fact that our immigration policies are disproportionately unfair to Black migrants. And so we want to join with our friends at UndocuBlack and other organizations in calling this out for what it is, which is racist.
Bill, thank you. I mean, lots of changes have been announced. Where do you think we're now, and what still needs to happen?
Well, we should end Title 42 today.
Yeah.
There's no it's a public health law. It fits in with things that have happened throughout our history. We've used public health as an excuse to limit migration into our country, and we're continuing to do that today. And it's really one of the worst vestiges of the previous administration that remains in place, and we should stop it right now.
Thank you, Bill. Yes, I agree with you. So, you know what, Callie, give us something. You and I work extensively on calls to action and how can we give information to our community? What can they do? Is there something that our listeners today can do, our attendees can take an action upon?
Yeah, absolutely. So we are elevating the calls from our partners that Bill just mentioned, from UndocuBlack, from Haitian Bridge Alliance, from African Communities Together, and from so many other Black-led immigrant organizations calling for the end to Title 42. As Bill mentioned, unaccompanied kids are no longer subject to this ban, and the Biden administration has said perhaps that families won't be subject to the ban anymore soon. The reality is the numbers are 800,000 individuals were turned away and 80,000 families turned away under this ban. It is affecting individuals, it's affecting adults, and it's particularly affecting people who have had to flee their home countries alone and are coming to the border for help. So if you go to this link that's here below us and also in the chat, you'll be able to fill out a form that will allow you to tweet automatically at President Biden and at Secretary Mayorkas calling for the end to this program. We ask that you join with us because this is among the most serious human rights violations of our time, and it needs to end.
Callie, thank you so much. You know what, folks, a lot of people wonder, and I used to be one of those people before I joined, first as a volunteer and then as a staff. What can I do? And is my tweeting or is my leaving a message on my congressperson's phone machine, would it do anything? Yes. I assure you, we are looking at the data, we're looking at the numbers. One time, our community left so many messages on a representative's machine that they had to move they had to show up for us. These are our representatives. They represent our intentions, our actions. We can hold them accountable. tweet at them, call them, sign a petition, look through our social media pages. You'll find a whole bunch of things. We're dropping some things in the comments section. And how can you help? You can volunteer. Please volunteer. If you have a little time to give, time is amazing. Give us a little of your time. If not us, give a little time to one of the community partners we have spoken of. If you need more information, contact us. You can contact us through our social. We'll get you set up. Advocate for these, for our immigrant siblings. Spread the word. Stand up for them. Show up. Speak up. Educate. Learn what it means to have a backlog on U visa. Understand what ACAs are. Figure out how MPP affects court cases. Understand how U visas work. And that education will help you advocate. And if you are so moved, donate. We are committed to this work. You have met a small number of our staff who show up every day and do this heartbreaking work, but there's just no other way for us. So if you find it possible, we have a July campaign, which is on our website, on our social media, or just send us a message and tell us that you would like to donate, and we'll connect you to the right people. But support the work, not just at HRI. Donate to all of the Black-led organizations who are doing important work. Donate to organizations who are on the ground helping children get out of shelters. Support the work, people. And thank you so much for being here today and for putting up with your very excited host. I thank the staff of HRI who make the city of Dallas proud every day. And I thank you for your time. If there are any questions that are still in the chat, we will get to them and we will be in touch. Folks, anyone, have I missed out anything? Do we need to look at anything before we shut this today? It is an honor and beyond, ladies and Bill. And thank you. Thank you, our community, our city. We are proud to serve you. We stand in solidarity with our documented, and we believe that Black Lives Matter. From Dallas, Texas, here's a goodbye.